State of Illinois filing their final brief before the 7th Circuit Court of Appeals in the ban challenge of Illinois firearm laws. You got the Protect Illinois Communities Act that's been challenged, and a district court said it's unconstitutional. Now the state's having to defend that in court, trying to get the courts in the appeals court to reverse the district court's ruling. Welcome in. It's Illinois in Focus Daily. We've been tracking this story really since before it even came into law back in January of 2023, and all of the litigation that followed thereafter in the state courts and then in the federal courts. Well, right now, the latest status is you've got the 7th Circuit U.S. Court of Appeals in the case Barnett et al. V. Raoul and Pritzker in the state of Illinois over the Protect Illinois Communities Act, banning more than 170 different firearms and semi-automatic rifles and handguns and banning magazines and even creating a registry of sorts. So let's get to the latest filing here, and to join me to talk about that is Todd Vandermeide. He is the Aurora Sportsman's Club president. He is also a longtime advocate of the Second Amendment, and he joins us now here on the line. Todd, thanks for taking time. Obviously, we're pulling this document up, so you got a chance to take a look at it. What are some of your initial thoughts?
It's pathetic. If this is what they needed extra time for, I'm amazed as to how thin it is. All they did was they recycled every worn-out argument they've ever made in the past. That they try to play to Judge Easterbrook with, a comment that, this is huge technology leaps, therefore they can be banned. Say, kind of citing him from Friedman, where they said that at the founding there were only single-shot muskets, there weren't semi-automatic rifles, which isn't true. But they just harp on all the same stuff we've seen for the last 2 years. They just spit it out all over again in a different format.
Yeah, and I think at one point they even point to a statistic about the percentage of citizens who own firearms that are banned in the state of Illinois, and it said something about like 0.68% of the Illinois population. Are they basing that off of the registration? Because that's another component of all of this as well that the district court said was unconstitutional.
It looks to be that they're inferring that the only people that own these are people who registered them, not taking into account that people own them and may have moved them out of the state, or just flipped the middle finger to Pritzker and company and said, we don't care what your law is, we're going to hang on to our guns. And we're not registering them, we're not telling you anything more about that or whatever. So obviously you were up at our club recently. You can you saw for your own eyes what kind of stuff transpires out here. I don't think we're 0.6% of the population in the gun owning world.
Todd Vandermeide joins us. He is president of Aurora Sportsman's Club. Also, you can find him on the YouTube channel Freedom's Steel. Just some of the arguments, again, back to what the state's trying to say is that these are dangerous and unusual. Saying they're unusual because only 6.6% of the population in Illinois actually registered a banned firearm with the state. Obviously, as you stated, a lot of recognition that just is not a real number. The compliance rate for that registration requirement, not near what I guess they were anticipating, but you've got the issue of dangerousness, and they say that semi-automatic firearms like an AR-15 has over-penetration concerns. Is that a legit argument here?
No, because what they don't take into account is an AR-15 fires a 5.56 millimeter, or the civilian equivalent is the 223. Yet they say nothing about dozens of models of bolt-action rifles, or even the Mini 14, and its, standard configuration, fires the exact same cartridge. Plus, you have all the big game cartridges going 30-06 on up that carry way more power than a 5.56. They keep trying to conflate this kind of stuff, and it's ridiculous. And if this is the best that they have for their arguments, the other things are that they're trying to play, saying that this panel cannot overrule Beavis and they're already hinting at an en banc ruling. I think they are hoping at best, that they might win, but I think they maybe resolve to themselves that there could be a split decision or a decision in our favor, because right now everybody is under the assumption that the panel that handled the Beavis motions is going to be our panel, and that was Easterbrook, Diane Wood, and Brennan. And Brennan wrote the dissent, siding with our take on the issue. Wood wrote the opinion. I believe it was ghostwritten by Easterbrook. But Diane Wood has since retired, and so they have substituted for at least up till this point, Judge St. Eve, who is a Trump appointee. Now, she was on the Viramontes case, which went against us 3-0, but it was a thin record in the Viramontes case. There was no trial. Everything that was in the record on the Viramontes case was simply submitted in paper form and, explained away. It's like, competing textbooks.
Well, and touch a little bit more on that, because, that's what distinguishes the Barnett case, that, it's not just Barnett. You got Federal Firearms Licensees of Illinois involved. You've got 4 different plaintiffs groups here. The other cases that they point to, indeed, it was just briefs and just decisions on the briefs. It wasn't, deep, testimony on the stand from expert witnesses like we have in the Barnett case, right?
Correct. And that's what makes our case so unique. There's 7,000 pages of a record with experts filing their depositions and their thing, those experts being put on the stand and asked questions in front of the judge even asking questions, then those experts being cross-examined by the other side. That all went on. You were down there for 4 days of a bench trial that we were involved in. Ours is a little different. And there's a growing feeling out there in the 2A legal world that this case is the one the Supremes may want, because final judgment, record, they've gone back and forth the whole 9 yards. So we've got that going for us here. The real wild card now is which side is St. Eve going to break on. If you read the brief, they are weighing, the state is weighing very heavily that this panel cannot overturn a previous panel. But the previous panel was based on an injunction. And they left open the door that, well, you can present evidence and possibly convince us to change our mind. So I think the state is very, very nervous about some things here, about what their possibilities are with a Trump appointee now being on the panel. And it'll be interesting. This will be the first really good test on 2A issues for Judge St. Eve to see where she's going to come down. So the question is there going to be some kind of nuanced, procedural thing that, we can't overturn this, however we would otherwise, or the state's already hinting at going en banc, and that if they lose, it would go, that they would certainly petition the full court for an en banc rehearing of this. I think that no matter what, somebody just needs to get up there in front of the court next month and say, we understand this isn't the last stop for this train, so whatever you do, rule fast, and let's get on with this.
And I think that's something I didn't even think about, was them asking for the en banc. And just for quick background for listeners, not necessarily as tuned into the judiciary as say you have been, Todd, and I've been just covering these things, but this is a 3-judge panel of the 7th Circuit U.S. Court of Appeals. That's how they do their cases. So if it doesn't go the way of a certain litigant, they can then request the entire panel, an en banc panel. So way more than 3 judges. What is it, like 7 judges or something like that? That would hear
13.
something. 13. All right. So you've got 13 different judges that are going to hear it again. If that was the request and it was granted, how much longer do you think that would slow these things down to get this into the hands of the U.S. Supreme Court?
I don't think we're going to ask for an en banc review if we lose, because we want to get to the Supreme Court. I think if we prevail or it's a split decision, I think they are going to want to at least go en banc and see if they can't eke something else out. I think that if we prevail, I don't think the state wants to go to the Supreme Court. I think their chances at the Supreme Court are very slim And I think that they would remember when we won the concealed carry case in Shepard and Moore v. Madigan. Lisa Madigan did not appeal that to the United States Supreme Court, and the prevailing thought was that you're the last state with a to pass concealed carry. You guys, if you go to the court and think about Shepard being Bruin 13 years prior, that we lose the whole country. So I think that if we prevail at the appellate court, I don't think the state wants to go to the Supreme Court, because then if the Supreme Court rules in our favor, they lose the whole country. I think so. There's a mixed bag. There's 4 or 5 different scenarios that can play out here, and we'll see which one it's going to be. But an en banc panel would be all the justices of the Seventh Circuit Court of Appeals rehearing it, and it's a crapshoot.
Todd, finally here, just one last response from you about the issue of really what this comes down to, right? I mean, it's essentially the government trying to dictate to the citizenry as to what firearms the government finds to be appropriate for that individual to then be able to protect themselves, their family, and their property. They say that the regulated items are not suitable for self-defense. Where are they wrong?
They're flat out wrong, because those types of firearms are perfectly suitable for self-defense. You've had a number of cases around the country where individuals have used ARs to stop active shooters and defend themselves, things like that. However, that's the misnomer. That is the lie that the state and the anti-gunners continue to tell. They keep trying to conflate that it's self-defense. Heller said that it protects all lawful uses, such as self-defense within the home. They keep trying to write out those 2 words, such as, in the first holding of Heller. It is that, if you want to collect AR-15s from every manufacturer because it's like collecting doorknobs, so be it. That is a perfectly lawful use. If you want to use it for competition shooting, fine. You want to use it just to have a real life, Call of Duty run out at the range, fine. Whatever the lawful purpose is good enough. They have consistently, ever since McDonald has come out, tried to undermine Heller and say it has to be self-defense. And that's nowhere near. That is the highest threshold of what is protected activity, but it's not the only protected activity. And this is the lie and the BS that the state, the other anti-gunners continuously try to push out there.
Todd Vandermeide, president of Aurora Sportsman's Club, longtime advocate for the Second Amendment, also known as Gun Santa, and you can find him on YouTube as well with Freedom's Steel. Greatly appreciate your time, Todd, and thanks for jumping on last minute. I texted him at like 6:30 this morning. Hey, they just filed their final brief. You want to talk about it? Sure. He was even getting ready to go do some more bulldozing, so greatly appreciate you taking the time, Todd.
All right, dude. Thanks a lot. Have a good day.
You too. All right. We'll talk with Todd again in the near future. Obviously, as we continue to track this case, the oral arguments are set for September 22nd. So that's coming up just around the corner. I believe the Seventh Circuit U.S. Court of Appeals does stream their oral arguments. So you may be able to just listen to that. But I'm going to do my darndest to get into that room as well so we can give it proper coverage. All right. A lot more to come up on all of that. So if you need to get your hands on that brief, be sure to follow me on X, and I'll try to link it up into the video here, this segment, by the time we get it up after the live show here. But just a reminder, we go live each and every weekday morning with the latest news and analysis here with the Center Square on Illinois in Focus Daily. So be sure to like, subscribe, hit that notification bell, and wake up with us each and every weekday morning. All right, so we've got much more to come, but I do want to also give you guys a little programming note. I'm off Monday, Tuesday, Wednesday next week. Just got to take those days off where I can find it. It's Illinois in Focus Daily.